An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know, by Randy Barnett and Josh Blackman.
United States versus Lopez, 1995. Though the words of the Commerce and Necessary and Proper clauses have remained constant over the past 2 centuries, the Supreme Court's interpretation of their reach has not. The Court's interpretation of the scope of commerce among the several states has not much changed since the founding. To this day, it still is largely confined to trade and transportation of people and things from one state to another, though one outlier decision from 1944 held that commerce includes insurance. However, the Court's construction of Congress's implied powers to reach activity beyond interstate commerce has fluctuated greatly. Join me on a brief history of implied congressional powers. First, in the earliest days of the Republic, President Washington determined that Congress has the implied power to create the first bank of the United States, over the objection of James Madison and Thomas Jefferson. Second, during his term as Chief Justice, John Marshall continued the broader Hamiltonian reading of implied federal powers in cases like McCulloch and Gibbons. Third, we studied the case of Prigg, decided during the Taney Court, which applied an even broader construction of the Necessary and Proper Clause to find an implied power to enforce the Fugitive Slave Clause. Fourth, in DeWitt and Hepburn, Chief Justice Chase narrowed the approach to Congress's implied powers, but then in Knox, following the appointment of new justices by President Grant, the Court adopted perhaps his broadest description of the scope of Congress's implied powers. Fifth, during the Progressive era, the Court flip-flopped. In E.C. Knight and Hammer, the Court narrowed Congress's implied powers to regulate local business transactions, but in Champion, it permitted the prohibition of the sale of lottery tickets. Then, in Schechter-Poultry, it reasserted a limit on Congress's implied powers and invalidated the National Recovery Act. Sixth, the New Deal Court in Darby ushered in a radical redefinition of implied federal powers by adopting the substantial effects test, which was then expanded further by the aggregation principle it adopted in Wickard. Seventh, these New Deal doctrines governing implied powers then continued on to the Warren Court and were used to uphold the Civil Rights Act of 1964, in Heart of Atlanta, and in Katzenbach, where the court added a jurisdictional hook to regulate interstate activity that used items that had traveled in interstate commerce. The Supreme Court would go nearly 6 decades before it struck down a law because it exceeded Congress's powers under the combination of the Commerce and Necessary and Proper clauses. That winning streak for the federal government came to an end in 1995 with United States versus Lopez. In 1990, Congress enacted the Gun-Free School Zones Act, which made it a federal offense for any individual knowingly to possess a firearm within 1,000 feet of a school. The law did not purport to regulate any commercial activity, nor did a conviction under the law require showing the firearm traveled in interstate commerce, a so-called jurisdictional hook. In March of 1992, Senior Alfonso Lopez carried a concealed weapon into Edison High School in San Antonio. Initially, he was charged with violating a Texas law that banned firearms in schools. The next day, the state charges were dismissed after federal agents charged Lopez with violating the Gun-Free School Zones Act. He was tried and found guilty. The Fifth Circuit Court of Appeals, however, reversed his conviction. The United States appealed the case to the Supreme Court, but was unable to articulate what limits existed on the scope of Congress's powers. During oral arguments, Justice Ginsburg asked the Solicitor General,
"What are the limits then? What would be a case that would fall outside?"
After an uncomfortable pause, he replied,
I don't have...
Justice Scalia then interjected,
Don't give away anything here. They might want to do it next.
The inability of the Solicitor General to identify a limiting principle to its theory of congressional power was fatal to the government's argument. By a vote of 5-4, the Supreme Court held that the Gun-Free School Zones Act exceeded Congress's power under the Commerce Clause. In his opinion for the court, Chief Justice William Rehnquist began his analysis by intoning, quote, "We start with first principles. The Constitution creates a federal government of enumerated powers." Next, the court quoted from James Madison in Federalist Number 45. Quote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite." Chief Justice Rehnquist added, "This constitutionally mandated division of authority was adopted by the framers to ensure protection of our fundamental liberties." The court acknowledged that Jones and Laughlin Steele, Darby, and Wickard had ushered in an era of Commerce Clause jurisprudence that greatly expanded the previously defined authority of Congress under that clause. Yet, he observed, even these modern era precedents, which have expanded congressional power under the Commerce Clause, confirm that this power is subject to outer limits. Rehnquist then identified 3 broad categories of activity that Congress may regulate under its commerce power. You can remember them with the helpful acronym CIA. First, Congress may regulate the use of the channels of interstate commerce. The court cited Darby and Heart of Atlanta as examples of Congress's authority to keep the channels of interstate commerce free from immoral and injurious uses. For example, Congress can regulate local activities that block the flow of interstate commerce. Second, he explained, Congress is empowered to regulate and protect the instrumentalities of interstate commerce, or persons or things in interstate commerce, even though the threat may come only from interstate activities. For example, Congress could protect ports and railroads from foreign terrorist attack, which are entirely interstate. Third, he identified Congress's authority to regulate those interstate activities that substantially affect interstate commerce. You will recall that the substantial effects test was established in Darby and Wickard. Those decisions found that regulating such interstate activity could be a necessary and proper means of regulating interstate commerce. With these 3 categories, the court attempted to synthesize nearly a century of precedent. But then, Chief Justice Rehnquist added something new to the doctrine. He identified an outer limit of the 3rd category, the substantial effects test. Congress could only regulate intrastate activity that is economic in nature. Even Wickard, which he observed is perhaps the most far-reaching example of Commerce Clause authority over intrastate activity, involved economic activity in a way that the possession of a gun in a school zone does not. The Gun-Free School Zones Act, he concluded, has nothing to do with commerce or any sort of economic enterprise, however broadly one might define those terms. Nor is it an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. For this reason, Chief Justice Rehnquist concluded that the Act cannot be sustained under our cases upholding regulations of economic activities, which, viewed in the aggregate, substantially affects interstate commerce. Justice Kennedy wrote a concurring opinion, joined by Justice O'Connor. He worried that were the federal government to take over the regulation of entire areas of traditional state concern, areas having nothing to do with the regulation of commercial activities, the boundaries between the spheres of federal and state authority would blur, and political responsibility would become illusory. Justice Thomas wrote a separate concurring opinion. In a future case, he hoped, the court ought to temper its Commerce Clause jurisprudence in a manner that both makes sense of our more recent case law and is more faithful to the original understanding of that clause. There were 3 separate dissents. Justice Stevens wrote, quote, "Whether or not the national interest in eliminating that market for guns in schools would have justified federal legislation in 1789, it surely does today." Justice Souter's dissent extolled the practice of deferring to rationally based legislative judgments as a paradigm of judicial restraint. Justice Breyer's dissent found that the Gun-Free School Zones Act falls well within the scope of the Commerce Clause, as this court has understood that power over the last half-century.
In September 1994, 6 months before Lopez was decided, Congress enacted a new version of the Gun-Free School Zones Act that included a jurisdictional hook.
Now, to be convicted of violating this law, the government had to prove that the firearm in question has moved in or otherwise affects interstate commerce. So amended, the law remains currently in force. Nevertheless, the court's decision in Lopez sent a shockwave to the legal academy. Many law professors questioned whether the court was serious in drawing this line. They stressed that Congress had become complacent and did not accompany the law with any factual findings to justify the law. Perhaps had it done so, the court would have deferred. Others wondered whether Lopez represented a step towards repudiating a century of Commerce Clause precedent, or whether instead the court had merely put a halt on the further expansion of federal power. We would only find the answers to these questions in the next two cases, United States v. Morrison and Gonzalez v. Raich.